So there you go. Part of the many questions about this is how did we ever get here? Well, to shed some light on perhaps what might have transpired, let's head to Abuja. Mark.
Thank you, Chamberlain. We have with us this morning Mr. Michael Ondaka, SAN, former Attorney General and Minister of Justice from 2007 to 2010, when the said contract with the Nigerian government and P&ID was signed. We also have with us Mr. Niyi Akinshiju, who is the chairman Buhari Media Organization. You do know that the Buhari government has been trying to absolve itself of any complicity in the fact they were now to pay $9.6 billion in judgments. So, gentlemen, well, welcome both of you to Sunrise Daily this morning.
Good morning.
Thank you so much.
Good morning. Well, Mr. Ondaka, I'm sure that, you have been speaking to the media. You did grant an interview to the Nation newspaper sometime last week, I believe, yes, saying that you know absolutely nothing about this particular contract and that there is no way we could have signed a contract of this magnitude without it passing through Federal Executive Council. But how did we get here? They did claim that the conversation started under the Yar'Adua government, under which you were Attorney General of the Federation. What can you tell us?
Thank you very much. A conversation is not a contract. And a contract of this nature is a concession. And a concession, we have laws in this country. You have Infrastructure Concession Regulatory Commission. That is the starting point of a contract of this nature. It must go through, and from what I see, is unsolicited proposal, because it is the P&ID that brought the proposal. It's not government that gave a tender. So unsolicited proposals first go to the Infrastructure Regulatory Commission concession. We call it ICRSCA. The act came into in 2005. It means if you bring a proposal for a concession, it must first go to them. They have to go through due processes, and then they give approval and advise council. And Section 2 clearly says that council, not president, must approve the concession. So if this did not come to council, it means it did not ab initio go to Infrastructure Concession Commission. Therefore, I don't see the basis in which the contract was funded.
But is it possible, is it in any way possible that the Nigerian government could have been having a conversation with a company that we're now being told, oh, never really existed, is a shell company? Is it possible?
People can come to make conversations and make proposals. But we have laws in this country. And this conversation here is situated on two principal elements. One, which requires sovereign responsibility. That the laying of gas pipelines is a sovereign responsibility. It requires budgetary provision. I have looked through the 2009 budget. I have not seen anything like that. So if I'm having a conversation and there's no law to make a conversation consummate into a contractual relationship, and people sit somewhere and do a contract which violates all laws of the country, I don't see how that contract could stand on the basis of law.
2010 was when we understood the conversation started. Did you follow the conversation? Did you hear anywhere, or did you ever, because we understand that the contract was actually signed in 2012. Did you hear anywhere that such a contract was signed anywhere?
I left government in 2010.
Indeed.
No, the contract was purported to be signed January 11th. And then I was the Minister of Justice. So I ought to have known, but I did not know. And therefore, I don't think, and the law did not say president should approve. The law said Federal Executive Council should approve. The Concession Commission clearly said the Federal Executive Council should approve the concession because there's underlying things that have to be considered. First, the issue of budgetary provision for it. Second, the return on investment. Two, the people are doing a commercial transaction. Our responsibility is a sovereign responsibility which have competing rights. For provision of gas pipeline, which was the basis of they claim repudiation of contract, is a sovereign responsibility of government. government have to budget for it. It has to be approved by government. Now, of course, if I come in here and I say I have a proposal, it does not mean the proposal will just cannot go to competitive evaluation, because we are still going to make you get what you have invested. So we have to evaluate and know that that thing has value. And it's properly, it has to go to Ministry of Finance, it goes to go to Budget Office, Debt Management Office, then it has to go, if there's aspect of it that requires funding, like in this case, the aspect of laying pipeline requires funding, it then has to go to the National Assembly for budgetary provision by the ministry. Then it will come to Federal Executive Council through a no objection. It has to go through the proper procurement processes. And this is where I think we have to look at this contract very well. We have to attack this contract from the germane beginning of the contract. Did it pass through these laws? Because no country will accept a situation where a contract is consummated in breach of its laws. Because in US, UK, you cannot spend anything unless Parliament approves.
This is 2019. Now, I don't know, maybe perhaps as a result of the fact that this has now become a controversy, we now have, dates and figures flying everywhere. But I did read that conversation on this contract started in 2010 and that it was signed in 2012. That was under the administration of President Goodluck Jonathan. As of 2010, well, sadly, President Geradua passed. So, and you have said that the conversation is not a contract. But, there's been ample time, it would seem, because this is 2019. There's been ample time to investigate and do all that we needed to have done on this contract. Find out first and foremost if this was a credible company. Find out how we got ourselves into this mess, because we understand that from when the Buhari administration took over, this matter was already in arbitration. And we understand that sometime in July, I think an award of $850 million, that is July 2015, an award of $850 million was granted to this body, to this company, by the arbitration panel. But here we are, they say, from lack of due diligence, we're now to pay $9.6 billion. What do you have to say?
I think there has been a lot of manipulation, manipulating the system, manipulating the media. And of course, the whole thing, it's turning out to be an international conspiracy, against the Nigerian state, as it were. Well, and perhaps to put it better, appropriately, more than a conspiracy, it's what I call a blue chip equivalent of a 419. Because the truth of the matter is the whole process lacks logic from the beginning to the end. You have access to some information. I have access to some other information. For instance, I'm on all fours with former AG here that this contract was signed, January 11, 2010. And that by January 12, Michael Quinn, the chairman of the company, has started writing virtually everybody who was anybody in the Nigerian state at that time. And the whole thing, was to create a judicial linkage. So from the beginning to the end, there was an initiative and an objective to achieve. And that objective was to defraud the Nigerian government. So starting off, there was already a stated goal. And that stated goal was this. The arbitration panel itself had issues. The contract itself, because when you come to the basis of the contract, supply of gas, from which field to what plant. In the proceedings at the arbitration, Mr. Quinn himself stated that they were going to acquire 50 hectares of land from the Cross River State government. It was also established during cross-examination that indeed no land was acquired. But the most important, most interesting aspect of the whole negotiation was that the field from which the gas was supposed to be supplied, to be piped to this space that was not available, could not even, had no capacity to supply. Don't forget that by 2007, all major oil wells in Cross River State were handed over to Akwa Ibom State. There were just a number of marginal fields. And in that statement, or in the proceeding, Mr. Quinn said they had negotiated with ADAX, which was operating OML 123. And ADAX, that field couldn't have possibly generate 400 million standard cubic feet a day of gas. It is not possible. It was not a major oil field. And ADAX itself was not even part of the contract. I wouldn't know how you want to pipe your gas to your plant without the owner of the mining lease being part of it, you know. And going forward, all through the arbitration, by July 2015, I think arbitration had been concluded because that was the second phase of what they call the final award. The first phase was to establish jurisdiction of the arbitration. And again, that is where you feel that something had been done before. You know, decisions had been made before the arbitration even got on stream, because part of the agreement, I'm not a lawyer, but by generalization, part of the agreement said that, yes, the seat of the arbitration could be in London, but could also be anywhere by the agreement of the parties to the contract. Now, going forward, July 2014, the arbitration panel insisted that it had the jurisdiction. And then by July 2015, it said it was going to rule liability against the country, against Nigeria.
But we were represented on that panel.
We were.
We were represented by Chief Bayo Ojo,
So
SAN, another former Attorney General of Nigeria.
So you now want to wonder,
yes,
who appointed? Was it the Ministry of Justice that appointed a representative, you know, on that panel? We also had a lawyer, and we've always been having a lawyer representing our interest, you know. 2013 to 2016, Chief Ayorin, the SAN, represented us. 2016 to 2017, Mr. Shashore Olashubo Shashore represented us. So we've always had, but like I said, the whole thing was a manipulation of the system. And don't also forget that just after this contract was signed, a hedge fund manager on Wall Street, VR Capital, bought 25% of P&ID. And that 25%, the VR Capital has a history of buying into sovereign debts, where a company or an entity had been able to secure something like a debt by whatever means or guise. It is part of the business of these hedge funds, you know, to buy into it and then provide money to push for the seizure and eventual, you know, arbitration, manipulation, and all that. So the whole thing, for me, is a criminal enterprise. That's the truth.
It might look like a criminal. That's what the Nigerian government is trying to make us believe. The Minister of Information, Alhaji Mohammed, has asked us to be patriotic about this. And indeed, I mean, everybody should be concerned that Nigeria has a debt of $9.6 billion to pay, and we should be concerned as to what exactly transpired in this particular contract. But shouldn't we know the true facts of the case? Shouldn't the Nigerian government present to us, you know, facts that would exonerate it, to say, look, indeed, it seems that we're dealing with some international conspiracy here, or an international body bent on scamming the country by presenting some other, because first and foremost, there'll be questions as to how did we get involved talking with a company that, you know, might be a potential scam company, so to speak. Is there any way in government that we do a background check on those whom the Nigerian government will eventually speak with? Or is this, you know, is this come one, come all?
Thank you very much. I think the government is going in the right direction. First, we must know what transpired, because fraud vitiates all judgments, even if the judgment has been paid. an allegation of fraud is established, the person, the judgment creator, has to refund the money. That is the position of the law. It doesn't matter. No matter, because it does not foreclose. Fraud can be discovered anytime. And one information and evidence is concrete enough to prove fraud, then it vitiates the judgment. That's the position of the law.
I'm talking about...
Let me, I'm going further.
Okay.
And that is where the federal government is going. And that's where I'm alluding. Fundamentally, you can't do a contract that is an affront to your law. That contract cannot exist. First, a contract that is outside what the law stipulates, to my opinion, I'm talking about personal opinion, do not exist as a contract. Even if I'm a minister, and I decide to bring a foreign company into my office alone and sign a contract, that does not make it binding on the country, because there's a procedure for award of contract. A contract that undermines the legislature, that is the budgetary provision, undermines two key critical legal statutes, that is Public Procurement Act and Infrastructure Regulatory Commission Act. It's a contract that really touches clearly on the borders of fraud. And if evidence establishes that fraud was and people connive, then the judgment can be impinged, because no country, this is a judgment founded on fraud is contrary to law and contrary to public policy, both in Nigeria, in UK, in any civilized nation.
What are the elements of fraud that you are seeing with this particular
Yes,
case?
because if you were to submit a proposal for a concession, the first place is Infrastructure Concession Regulatory Commission. I have seen today's paper. I saw yesterday's paper in The Nation on the front page. I did not see anywhere Infrastructure Regulatory Commission is mentioned. So who is going to regulate the concession? Because they are the only people statutorily vested in Nigeria with the power to regulate and monitor concessions. So, but I did not see where any one of them is mentioned. And then how would you, if a contract, the law stipulates that the contract must be approved, of such nature must be approved by Federal Executive Council. It does not say the president can even give an anticipatory approval. Section 2 to 3 of the Infrastructure Regulatory Commission stipulates that such concession must be approved by the Federal Executive Council. It's a fundamental issue that can be raised anywhere that touches on fraud. If it is not brought to Federal Executive Council, why was it not brought? These are the main questions to act to impeach on the foundation of the contract. And if the foundation of the contract is founded on fraud, it cannot stand.
Tell us how arbitration works. Is there room for appeal in arbitration? Because
two ways. There's room to, you can commence a fresh action. Yeah. If you discover fraud, the law is there. And I think the Attorney General is my friend, and the people, the vice president is the son. The law is clear. Two methods when fraud is discovered. You either go on appeal to seek additional evidence, or you commence a fresh action and allude to the fact that this judgment is founded on fraud in the fresh action. And if the fresh action proves the fraud, and this is fraud because the contract violates the Constitution. Constitution of Nigeria stipulates that in Nigeria, before you spend public funds, it must be appropriated. The contract violates the Public Procurement Act. There must be competitive evaluation. Even when you have a right of first refusal, it must be competitively evaluated. The contract violates the concession, infrastructure concession law. Therefore, how would you stand a contract that violates all laws, no known laws in Nigeria, and that you still want the country to cough off 9.6? I am concerned because I'm a Nigerian. And this is not time for blaming anybody. It's time for us, every Nigerian, no matter what, to support the present government to fight this judgment, because the judgment can cripple. I have a small rice mill, and if this judgment is allowed, how can we get letters of accreditation? So I am concerned like any other person, like my colleague here, I'm concerned.
Well, you said this is not a time to blame, but the federal government is saying that heads will roll. It does mean that some people must take responsibility.
Don't get me in the wrong concept. I say everybody should not say this government did not take action. That's what I meant. Of course, people who got involved in this mess, including the foreigners, have to face the Nigerian law. This will demonstrate to the whole world that we are not a banana republic.
Well,
because you cannot do this type of thing in US, you cannot do this type of thing in UK. You cannot just spend 1 kobo out of UK.
Let me bring
money.
this to your attention. The federal government is saying that they are not going to negotiate with P&ID. Is that a wise decision to take?
Because if you are alluding criminal investigation against people, how can you at the same time be investigating with a criminal?
You didn't quite answer my question in terms of, because how did we get into conversation with a criminal, in quote, in the very first instance?
Because it is not the country that got in the conversation with a criminal. Individuals. Who are part of the criminal, alleged criminal group got into conversation. Don't misquote Nigeria. Nigeria has its laws, and the laws are the basis in which contracts are entered into Nigeria. But if people go in their own wisdom, sit somewhere, connive and do a contract that violates our law, you cannot say Nigeria entered into a conversation with those people.
Let's get some questions from my colleagues in Lagos.
Well, Mr. Ondaka, I'm just wondering, because if you say that if those contracts have not fulfilled the procedures required of us here, they cannot assume that we have entered into a contract. But, you know, just listening, are they supposed to be the one to ensure that we follow through with our process? And if we had representation, shouldn't we have proved that all of these things didn't meet up with the requirement before we got to this point of 9.6 billion?
Well, what happens if something happens in secrecy? It is very difficult. You say, I was a member of council, Federal Executive Council, I was the Attorney General, and I did not know. If you see what happens, nobody is mentioning the DG of Infrastructure Concession Regulatory Commission. Then something happened, this thing happened in secrecy. It is just coming up because I myself saw it on the pages of, the newspapers, the DG Infrastructure Regulatory Commission, and one member, Mr. Bernard, I contacted him. He was also shocked because he was a member of the Infrastructure Concession Regulatory Commission. When I contacted him, he was the deputy, like the vice chairman of that concession board. He was also shocked. So everything that is coming to us now is shocking. And I believe that if investigation is thoroughly done, people who sign the contract, if they have the authority to sign, mind you, ignorance of law is not an excuse. If you are a foreign company coming to enter into a contract, you also supposed to know the law. You also, because you must have done your due diligence, you're supposed to know the law. You're supposed to, appropriation law is, or act is a law. So you must know whether the element that relate to your contract is appropriated in the budget. That should be 2009 budget. If it is not there, how will you want to enter in a contract that the contract itself, the element that is very critical to your contract, is not in the budget?
All right.
That is one aspect that if you don't check, it's not an excuse.
We'll come back to follow up on this train of thought, and I'll let both of you respond to some of the information that is circulating about this matter in a moment. Do stay with us. Welcome back to Sunrise Daily. Well, let me continue with the former Attorney General. Yes, you did say that ignorance of the law is not an excuse. There are many who will say, look, that suggests that it applies both ways. But then you've highlighted some errors, things that were not properly done here regarding this contract. But is that saying that we are in some way saying, look, we didn't get it right, mistakes were made here, and as a result of that, we're not taking responsibility of what has happened, even though there's a judgment?
I'm not saying that. I am saying that if the investigation goes on and it is clearly established that fraud or fraudulent elements existed, fraud can vitiate a valid judgment. That's what I'm saying.
So whose responsibility is it to do?
Because one issue is this.
Yeah.
Others, originally, that area they said others was to supply gas pipeline. When we handed Bakassi, was no longer part of Cross River. In 2009, Bakassi was handed over to Cameroon. So I wonder how that could have been possible to depend on another sovereign state to supply gas pipeline.
Okay,
These
but
are the issues. Investigation will come out with all those things.
Ask you,
And
I mean,
if it comes out, I'm not saying there's fraud at this moment, but
okay.
I'm saying if fraud is established, then fraud vitiates a judgment. Even when the judgment creditor is paid, but fraud is established, that the judgment was obtained by fraud, then the judgment will be nullified and it will return the money.
Okay, so could you shed some light a little further, if you will? Whose responsibility is it to do the due process? Is it the government or the contractor?
Contractor also have a duty. When you are to invest in any country, you must ensure that what you do is transparently and it complies with the laws of that country. And if you circumvent the laws of that country and enter into a contract in breach of the laws of that country, then it will be a serious issue. For instance, you cannot contract to violate a fundamental law of the country or to violate the constitution of that country. You cannot just say now that you will enter into a transaction, but the attributes of that transaction will breach the laws of that country. And I'm saying that if a concession contract agreement was entered into and the infrastructure concession regulatory commission, which ought to give to process and send it to Federal Executive Council, did not do, that contract has fundamentally breached Section 5 of the Constitution. It has also fundamentally breached the provision relating to the budgetary provision, which gives the National Assembly the power to legislate and make budgetary provision for the execution of that contract. Because one aspect of the contract deals with the National Assembly, because the laying of gas pipeline must be budgeted for. If these elements were not done, and yet a contract was purportedly signed, it's a serious concern that if the evidence in the course of investigation show fraud, assuming an investigation revealed that Bureau for Infrastructure Regulatory Commission clearly wrote that this contract is not viable, or it was not brought to them as required by law, then there's a serious allegation that of fraud, likelihood of fraud, and if established, it can vitiate the judgment no matter how well-founded the judgment is.
Yeah, Mr. Akishi, I'd like to take you up on this one now. Given what you have said earlier and what Mr. Ondoaka has also said, SAN, where do you think we stand at this point, given that, as it is, Nigeria stands indicted so far in all of the processes that we have, even between 2015 and now, and all of our inactivity and all of that? Where do you think we stand now?
Well, I think the first thing is to continue to investigate this matter, as it were, with the intent, with the purpose, objective of unveiling the actors, the real actors behind, the scam. Lawyers may say it's alleged, but as far as I'm concerned, this is a clear scam. When you look at all the milestones in the contracts, from initiation and, of course, to arbitration, you are so uncomfortable, except you've not executed a contract before. If you had, you see those milestones are not as appropriate, even what triggered the arbitration was supposed to be repudiation, you know. Meanwhile, that is, once any party to the contract, you know, repudiates the letters, the spirit of the contract, then the arbitration and conciliation aspect of the contract would be triggered. Now, it's the same Mr. Quinn, you know, that wrote a letter to, you know, allegedly to the federal government that it's as if the federal government was not interested any longer in the contract. And to that extent, it was repudiating the contract, to which the federal government accepted. And on the note of that acceptance, that was the major reason he went into arbitration. He called for arbitration. And it is curious that at that point in time, the Ministry of Petroleum Resources would go into arbitration and, of course, select or nominate Nigeria's representative on that arbitration.
Okay, Mr.
without
Akishoju,
consultation
if I may
with the
come in
Office
now,
of the Attorney General.
Mr. Akishoju, if I may come in now. Now, this,
Yeah.
I mean, from the facts and details we have available, this appears to be an investment gone wrong. Now, according to P&ID, they say, you know, investors or countries like Nigeria need investment, as it were. In fact, countries need investment in general. And in turn, P&ID said that the countries need to protect investors. And according to a statement they put out, they said if the rule of law in developing countries is weak enough to permit those countries to disregard their contracts, investors will be less willing to invest in developing countries. P&ID is painting a picture as though the country is not investment friendly. How do you respond to that?
I noted earlier that the whole thing, it's about a predetermined end. And the whole statements that we're seeing, aside what you have read, newspapers and media houses had published statements purportedly signed by Mr. Michael Quinn, who was chairman of P&ID, you know, up to 2015. He died April or May 2015. And the same Michael Quinn is still signing statements in 2019. You see the latest one being the one purportedly atomizing the actors and, of course, state officers that were behind the contract, from late President Yaradua through to President Buhari, and that he met all of them. Michael Quinn had died since 2015, and whoever are his agents in Nigeria are still signing, you know, statements in his name. So it tells you the intention behind the whole thing. So if we're talking about being investment friendly, being investment friendly is principally driven by due diligence. If some actors, some state actors.
Let me bring this, just to follow up what you said about that communication, because there's so many circulating out there, because even as at May the 3rd, 2015, according to P&ID, they say that they offered to settle the dispute with the Nigerian government for, at that time, $850 million. And that President Goodluck Jonathan indicates that they are handing over the negotiations to the incoming Buhari administration. That was as at May 3rd, 2015. But then it goes on to May 27, 2016, the arbitration tribunal wrote the Nigerian government confirming that, and it says, quote, as the parties will be aware from the procedural order number 12, the tribunal has decided that the seat of the arbitration is England. It follows that the Federal Court of Nigeria had no jurisdiction to set aside its award. And it goes on. So this suggests, according to them, that there was indeed communication between themselves, the former government, even this government, because further communication indicates here that the Attorney General, Malami, was also notified and at some point spoke about this matter, writing to P&ID. What do you think of all of this circulating out there?
Can I say something? All right. Let me say something. First, that position is very absurd because Clause 20 of the SPA, that the agreement, said Nigerian law should govern that transaction. It was very explicit, Nigerian laws. In fact, they wrote laws of the Federal Republic of Nigeria should govern the transaction. Therefore, it looks very strange for that piece of agreement, which was very specific and direct, should be ignored to say that a mere supervisory law, role of the commercial court in England we exclude where the parties have agreed that the laws of Nigeria should apply. It's very, very strange because the sitting of the arbitrators could be in London.
Okay, what about this piece of information as well?
The Nigerian law.
Just one more thing. Could you also speak to this matter? Because they also say that as at April 28, 2017, after the 60 days had expired, they said they were communicating, but a certain 60 days had expired, Attorney General Malami instructed his lawyers to write to P&ID's lawyers and explained that, quote, the delay was occasioned by the bureaucracy of the federal government in a bid to determine a reasonable strategy after receipt of the arbitral award, end of quote. The Attorney General's lawyer, audit, according to them, says again, quote, we now have the authority of the Vice President of the Federal Republic of Nigeria to meet with the claimant and negotiate the terms of the arbitral award, end of quote. What do you think now?
Yeah, that is what they're claiming. Because there's a lot of manipulation in this process. That is what is their claim. That is what they're claiming. As my colleague here just said it, somebody who died, they're saying he's the one claiming all those facts. So we need to be extremely careful. And the one important thing that we should not ignore is the fact that, let me just draw you back slightly. The fact that you are investment friendly, or a country should be investment friendly, does not mean people who come to invest in this country should disregard the laws of this country.
Let me quickly jump in here. You have made that point, but you know, while we're still verify whether this contract was signed in 2010 or signed in 2012, if it was signed in 2010, would you be willing to accept any responsibility for the fact that, you know, such a thing happened? Because there are those who say that the circumstances prevailing at that moment was what would have led to a thing like this. Let me be clear on this. The president then, President Umaru Musa Yar'Adua, who's late now, was in hospital in Saudi Arabia at the time. And there was a huge controversy at the Federal Executive Council as to whether or not the then vice president could have been acting president, which you played a role in. Would you be willing to accept any responsibility for the circumstances that could have led to the signing, assuming it was done in 2010?
I will not accept the fact that, yes, they say the contract was signed on 11th January 2010. And that if it was done at that time, honestly, I will tell you the contract was illegal and void. On two grounds. First, the president was not there. There was no capacity to authorize the signing of that contract, except if that was jointly done in the Federal Executive Council.
Now, we haven't seen the details of the contract.
Yes, I'm telling you.
We do not know who signed this particular contract. We do not know if it was more than one person who signed the contract. We do not know the officers involved. But looking at the circumstances that prevailed in 2010, and the fact that you at that point in time said that the president could rule from anywhere, people could have claimed anything, that they got authority from wherever it was that they got the authority from. Would you be willing to take responsibility for it?
I am saying, look, even the president under concession law has no power. If I say the president could rule from anywhere, it's a different thing. As the power to sign this contract is a different thing. The law that regulates this contract, say it has to be approved by Federal Executive Council. It was not done. And the issue of whether it was signed by anybody is an immateriality.
Both of you have not responded to how we vet people, how we vet companies that come to do business with the federal government. If indeed the federal government is now saying that these people are a fraud, they're a scam, they're, you know, all manner of things, did we have a process in place to vet you know, the kinds of companies that come to do business with the federal government of Nigeria?
Thank you very much. That is why there was infrastructure regulatory, concession regulatory to vet them. And if they did not go there, that is where I say that fundamentally we had a process, a law, the law established an organization that can vet this type of people who will want to participate or enter into contract under these circumstances. They did not go there. They did not even go there. So if this, because from even what they have been saying, they have never even said one day that they went to Infrastructure Regulatory Commission office and they submitted their proposal. They have not alluded to the fact. They have not talked about they got no objection from Infrastructure Regulatory Commission. They have not said that. Therefore, if we have a process, and they are aware of it, because they were in the country 2008, and Infrastructure Regulatory Commission was enacted in 2005. So ignorance of law is not an excuse.
Do you want to quickly say something quickly?
The company itself was registered 2006. So it's as if it was registered to come eat Nigeria, as it were. And let us quickly note this. There is no space, there's no place in the proceeding of the arbitration that negotiation, you know, was made for 850 million. As at July 2015, at the second phase of the partial award, what was considered, and the judgment was the fact that, yes, Nigeria is liable. There was no quantum in terms of damages. You know, the quantum on damages. That, I mean, you had so many adjournments and all that came to January 2017. That was when you now started having consideration for damages. So there was no consideration at all. So when a company of that nature is making this kind of claim, even when we are all alive, there's no way it can be trusted. I can't trust it.
It's a fine place to leave it, gentlemen. We do know that, you know, facts will continue to unravel and there'll be questions, you know, to be asked, and hopefully we'll be able to get answers. Hopefully they will not be rhetorical questions. But let's leave it here. We have to thank you both for coming on Sunrise Today this morning. Michael Ondaka, SAN, is a former Attorney General and Minister of Justice of Nigeria from 2007 to 2010. And Mr. Ni Akinshiju is the Chairman, Buhari Media Organization.